To buy a business, here are the must-have legal docs to close your deal. First, we have the non-disclosure agreement. You're gonna have to sign this every time you wanna look at a listing. All it is just saying that you're not gonna talk about what you learn. It's really important that the customers and employees or anyone in town not catch wind of the sale. It can really have a negative impact on the business. So the non-disclosure just means you're not going to talk about this. Now, usually within the non-disclosure, you're still allowed to work with your advisors, such as your accountant, your attorneys, or your banks. So you are allowed to disclose to third parties that also have some level of confidentiality built into their relationship with you. Next, if you find a business you like, you're going to have to fill out your letter of intent. So that's just a really simple document laying out the basic terms, the price, how much of the deal is going to be on a promissory note, whether the real estate's going to be included, rent, just a general overview of some of the terms of the deal to see if you have a general agreement so that essentially you can lock in this business, come to a deal with the seller, and then you go on and you start the higher level of due diligence. Now, an LOI is a pretty simple document. It's non-binding. There are online templates for it if you need one, because typically the LOI gets completely offset by the purchase agreement that we'll talk about later. So after your deal is accepted, there's gonna be an escrow agreement. So typically as a part of the LOI process, you're gonna agree to put some money into a bank account as a show of good faith that you're a serious buyer. Just be careful there. Some brokers ask for really high amounts. Some that ask for like 5 or 10%, which is just crazy. Typically we do like $5,000. Sometimes we'll do a little higher, but our default is just like $5,000 into an escrow account. And as you do that, you're gonna get the escrow agreement that just lays out the terms. So you wanna make sure that there are lots of ways for you to get your money back if the deal's not going to go through. So if there are any problems with the business, or if the seller misrepresented anything in the initial presentation, that you can get that cash back that you put in. Next is the purchase agreement. Now, this is probably the most important document, and you should absolutely have this filled out by a living, breathing, experienced acquisition attorney. Don't get a estate attorney or don't get a criminal law attorney. Make sure you get someone who specializes in business acquisitions to do your purchase agreement. It is the overall governing document for really everything that you're doing, everything involved with this transaction. So it has to be done right. It has to be done well. So it's going to go through, there's probably 30 to 50 really important factors that it's going to cover in there. And that's why you want to make sure you have an experienced professional do that purchase agreement for you. Now, as your attorney is doing your purchase agreement, there's going to be a few documents, ancillary documents that kind of go along with it. It's going to be like the transition service agreement that just defines exactly how the seller is going to help you through the transition process and what the consequences would be if they don't. So whether that's a cancellation of the seller note, or if there's some holdback funds or anything like that. You're gonna have employment agreements. So if you have a general manager in place or any key employees or an employee that's gonna hold the license for the business, you're gonna need an employment contract for them. And the bank's going to require that. Your lawyer's gonna write that really as a part of doing the purchase agreement. Then last, when we're finally at the finish line, you've got the bill of sale, which is just the actual document that transfers assets from one owner to another in the case of an asset sale. And then if you're doing a stock sale, you'll have the stock certificates. Those are the documentations that show the actual ownership of the legal entity. The seller is going to have to sign off on those and transfer ownership to you, the new buyer. So we just scratched the surface here. One thing we've learned by experience is that hiring good legal help makes your deal go so much smoother. A good lawyer is typically going to cost $20,000 or more. So you have a $20,000 minimum and then usually about 1% of the deal price. Money that you pay for that counts towards your equity injection, so it reduces the amount of cash you need to take to the table. So there's really no reason not to get a good attorney because essentially you have to spend this money anyway.